attorney in Edison, New Jersey, and this is basically geared towards people that are attorneys preparing documents, but anyone can listen in the future. And we kind of start off with many times like the people's office gets a ring, and that should be a happy ring because it's clients that need you. But you kind of want to. Many of the callers right away say like, "Oh, how much, how much, how much?" Because they're looking for the bargain basement, and you don't want to be known as the person that does a $50 will or a cheapy will. You want to be known as someone who does good, competent work. Just like I knew when I needed knee surgery, I called Rutgers track coach. Hey, who's the best guy you got? Because people should be willing to pay for quality services. So sometimes people also will say, well, why do I need to have a will? And this is the question that often gets posed to people at when they're with friends or at the Elks Club or non-lawyer. Why do I need a will? Doesn't everything go to my wife or spouse? Because number one, it doesn't necessarily, even if someone has like children and there's a prior relationship, the kids get something. If someone doesn't have a will but have parents, the parents sometimes get something. So the whole idea is to try to make it as easy as possible. So it's important to explain, if someone does not have a will, the procedure to distribute assets becomes much, much more complicated. So basically it requires all the children to sign a renunciation affidavit saying, yes, I don't want to be the administrator, and I've agreed that this brother or sister can do it. Let's see, and it got to be signed in front of a notary. If all of them don't do it, then there has to be a complaint order show cause filed in the Superior Court, and then you have to go in front of the Chancery judge and have that Chancery judge, appoint the person as administrator. So instead of spending $400, $500 on doing a will, they're spending over $3,000 on this complaint order show cause. So a lot of times you want to explain to people, having documents is an investment. You want to have it, you want to have things done so that you can make it as easy as possible for the family. Number two, if there's no will, then and not the spouse, the administrator has to take out what's called a surety bond. So again, they're spending $1,000 a year or whatever for each year, and some people can't get bonded because their credit's bad. Let's see, number three, if there's no will, or if it was people do use these cheap things and they do them wrong or sign them wrong, state law determines who gets assets, and you want to explain to people, who do you really want to get your assets? Because more and more people are leaving assets to their grandchildren rather than their kids. They leave it to their kids. Oh, wow, great, my son can have a bigger boat. Instead, they leave it to their grandkids. Their grandkids can use it for education, for weddings, things like that. When people don't have wills as minor children, I tell people it's a stranger at the courthouse who decides. It's like, right now it's Judge Daly, but who's ever handling probate in Middlesex. But the most important thing is it creates sometimes fights, lawsuits amongst the family. So you got to explain to people, when the family is grieving, do they need one more thing to have to worry about? No. Let's say they don't want to have financial things. So preparation and getting it done are important when you're talking to your friends, colleagues. And I've done wills and powers of attorney for attorneys. Very experienced personal injury attorneys who goes, Kenny, listen, I don't know anything about this. I don't want to know anything about this. I want to get good money for people who are injured. You do for me what's right. And believe it or not, New Jersey did away with the estate tax a couple years ago. New Jersey, has a very for inheritance tax, there's no taxes going to children, grandchildren, stepchildren, parents. So believe it or not, New Jersey is the probate easiest state. I mean, the property taxes are the highest. Everything else is the highest, but New Jersey is an easy state if you have a will and you've done some kind of planning. So when you're talking to clients, a lot of times people are put offers. Well, I can't determine who would, who's going to be the guardian of my kids. It goes, oh no, that's an easy thing for you to determine. Let's say you can't leave the room, or your house for 2 weeks. Who would you trust to watch your kids, and who don't you want? Because if it's not in writing, then that person who you don't think would be the best could petition the court. You also want to explain why it's important for people to have clauses to say, listen, 18-year-olds should not be inheriting money. 18-year-olds don't do anything wisely. I mean, if any of you people got money when you're 18, I know I would have bought a fast red car and drove to Seaside and rented a place for the summer, and hung out with my friends. And also advise your clients, beware of these cheap online things. In a way, they cause more problems. A lot of attorneys make their money in will contests, but and when you're talking to your friends and colleagues, say, listen, you could watch a YouTube video, do your own electrical work, but we wouldn't recommend it. You could watch a YouTube video doing your own plumbing, but if you don't do it right, and the second floor toilet's leaking, it's going to cost more to have everything fixed up. So now, one of the things that I used to insist upon prior to March 13th of last year is everyone had to come into my office, and I wanted everyone to fill out a form in their own handwriting, so I knew it was what they wanted. And back in January of 2020, a couple of my clients emailed me their questionnaire, and instead of handwriting it out ahead of time, and I remember sitting in Florida, looking at the Intercoastal, doing wills and emailing back to my office. I goes, wait a minute, I'm the dumbest person around. I should have been having people type it up for years. Why am I having it in anyone's handwriting? I can still talk to them. So we changed all our forms in February of 2020. So when the planet closed down, we didn't really lose a lot of time, because we could still email out the questionnaire to everyone and get things done. So logistically, well, so what we do now is we have a simple will questionnaire. My one from 20 years ago, it was 8 pages long and asked all about stocks and things like that. Well, since New Jersey did away with the New Jersey estate tax, back then the estates over 675 were taxed. Now for federal, it's $11.7 million, and I know a lot of people in South River have 11.8 million, but not that many people in South Edison. And so by emailing it to people, they can type it up at their own leisure. They email it back to you. Let's say they're less convenience. You're not worrying about how to make an appointment for someone, when to come in. I'd say they do it at home. You look at it. I got that hands-free thing on my new car, so I'm talking to everyone, because again, when I'm in the car, I got all the time in the world. I don't mind talking to a client for 15, 20 minutes, because what else do I have to do? I got the next call to make. When I'm in my office, your staff is asking questions. You got your laptop, you got this, you got that. So when you're driving, aside from trying to be as careful as possible, so the people type up whatever kind of questionnaire you have, and you want to say, listen, if you can't figure out something, and then one of the reasons you call them back is, I find it's very common where a married person puts one of their kids as the first executor, another kid as the second executor. Who's going to get their estate? Their kids. And I have to call them up, and he goes, so you want your husband to get nothing, and you don't want your husband to be the executor? Oh, and they say, I assume. I goes, no. So I will revise it. The other thing that we've changed in our practice is how to get paid. Let's see. Well, I signed up for Lawpay. People provide their credit card information. They don't need to give us the credit card with the chip and put it in the machine. It's typed onto the computer, and then then it goes directly into our account, and we're not worrying about walking around depositing checks. We do have old-time people that say, I don't do credit card. I don't want to do credit card. Hey, no problem. You can mail it to us. We have a mail slot in our office, but ever since COVID, we've kept the front door locked, because I don't want people just walking in off the street. So we make people have appointments if they're coming in, typically for probate matters. Then logistically, what we do is we prepare the documents after we're paid. We prepare the will, the power of attorney, the living will, and I'll go into that. Email it to everyone. and then I call them up again. And the form says, please print out and then read. It doesn't say, and it says, do not read online, because down the road, most of the people have preferred to sign their documents with instructions at the UPS store or in front of a notary on the weekends or after hours. When before COVID, we'd have to say, have to come in, between 10 and 11:30 or between, and a lot of people says, well, I work in the city. What's your night hours? I goes, or what's your weekend hours? He goes, I'm not coming in on Saturday. Saturday's running day, or Saturday's karate day. So we've tried to make it as easy as possible for the clients by sending things out, instructions on going in front of the notary, and then I end up typically calling people once a week and saying, okay, have you printed it out? Have you signed it? And I'm going to go into a little bit that's within the will, but in our instructions, we also recommend people nowadays to scan their power of attorney and email to their financial advisors, their bank, their life insurance people, anyone who deals with their finances. That way it's on their record. But you do want to tell your clients a scan will cannot be probated by the county circuit. Only the original can be admitted to probate by the county circuit. To make it easy for some people, I says the circuit looks at your scanned will just as they would look at a photocopy of a $50 bill you lost. Can't do anything with it. Let's say if you can't find the original, you want to tell the clients, prepare a new one. Let's say, because otherwise you got to file a complaint order show cause to have a photocopy admitted. Everyone has to be notified. Okay, so logistically, your will questionnaire basically is asking, okay, what's your name? Type in your name. And the great thing is, we used to have a lot of spelling errors. And South River Sayreville was our Polish and Russian and Eastern European people. Edison, where I'm at, we have much more people from Asia. And I couldn't pronounce the names. A lot of times I couldn't read people's handwriting. Well, we did away with that by having people type in who they want. So when there is a spelling error, it's usually because the client typed it in wrong themselves. So it is important to ask questions dealing with real estate, because if someone owns a real estate in another state, you want to explain that they still have to go through a procedure in the other state called ancillary probate. But a will that's done in New Jersey is still valid in any other state in the United States. But there's a difference between what is valid and what is best for someone. My mother-in-law used to ask me every other year, I want to come in and get a trust. I want to come in and get a trust. And I would ask her, why? Were you watching Susie Orman? And she goes, oh, yes. I goes, hey, Susie Orman is so right. If you live in New York, Florida, California, where the probate process is very complicated. But New Jersey, typically that's going to be one of John's main topics. In New Jersey, basically, the surrogate needs the original will, a death certificate, the information sheet filled out, and a check for $150 or so, depending upon how many surrogate certificates you wanted. And there were times when the surrogate's office is still closed to the public, but before they were closed due to COVID, if someone came to see in my office at 11 o'clock on a probate matter, and I said, okay, do you have the original will, death certificate, check for a checkbook? They'd say yes. It goes, okay, leave now, go to the surrogate's office with these originals. You'll be out of there in 25 minutes, and then come back before lunch, and then I can go over the next step. Now we instead, depending upon the surrogate, we either email or fax the specific county's information sheet. We send them a copy of the will, copy of the death certificate, any other form. A lot of counties have their forms online. Then after that, the surrogate sends to us paperwork that our clients have to sign in front of us. And then we send it by certified mail or UPS back to the county surrogate. Then the person becomes the executor. So I ask a lot of people, okay, why do you want to spend, $3, $4, $6,000 setting up trust when New Jersey is so easy in probate? Now John will talk a little bit more about that, but let me continue. Um, you we asked some questions dealing with assets, but again, because New Jersey estate tax is eliminated, most people don't need that. But you're not doing your job unless you explain to clients that a will can't change who gets assets if they pass directly to that person. So the main thing is like the house. The house's own husband and wife, that's tenants by the entirety, goes automatically to the surviving spouse. The will can't change that. If there's bank accounts that are payable upon death, joint tenants and rights of survivorship, automatically goes to that person. A will can't change that. So many times, the mom puts the daughter on for convenience, and you want to explain to them that, listen, if you're if you pass under the law, that child automatically gets it. Now, every one of your clients is going to say, "Oh, I know my daughter would do the right thing," and the answer is, of course, they're going to do the right thing while you're alive. They're not going to look you in the eye and say, "Hey, after you go, I'm going to screw my brothers and sisters and keep everything." So, but you want to explain that. Certain assets pass by contract. Think of IRA, 401k, SEP, life insurance. It doesn't change that. And if you have clients that have younger children, tell them get a printout of who the beneficiaries are. That way you can put it in your will folder, but also make sure that's who is best. Some of the life insurance people, they put spouse as number one, children as number two. But if the children are minors, that means that they get the money on the day they turn 18. And going back to how many 18s would spend money wisely, and every kid in that person's high school would know that, hey, on the day that he turns 18, Kumar is going to be a millionaire, or is he going to get $500,000? Let's, Kumar is going to be our new best friend and get him to pay for our prom table, etc., etc. So that's important to explain to people. Even though people type things up as their beneficiaries, you want to go over again, is this exactly what you want? You want, and more people are, they sometimes say, do I have to treat everyone equally? And at one of the programs we did for a library, I asked a lady, like, what's your concern? And she says, well, one of my kids, we don't hear from much, lives on the West Coast. I goes, well, let's ask you a question. On your birthday, did you get a card or a call? She goes, no. How about Christmas? Did you get a card or a call? She says, no. How about on Mother's Day, a card or a call? No. So I go, well, the question is, why should you leave this person anything? They haven't helped you out. They don't care if you're alive, and they're going to be the biggest pain in the rump if you pass away. All you need to do is you can put in a clause that nothing to this person or their children. You don't leave them a dollar. You don't put a reason. Nothing. Let's see. And the will should always have an explanation. If this person passes, who would get their share? You have clients that said, well, I'm not worried about that because all my kids are young and healthy. I goes, yes, they're young and healthy, but can you guarantee that there's not going to be an accident or something going to happen? No, you can never guarantee anything. So if someone passes, who gets their share down the road? Now, more and more people are saying, you know what, I'm not going to leave it outright to my spouse. Not because they don't love a spouse. Sometimes it's second marriage. Sometimes it's an easy, quick way to at least protect some assets from Medicaid. So, explain to the clients, listen, instead of having everything go outright to your spouse, you could have them, at least they get the house automatically, but you could have it go into a trust for that spouse's benefit. Therefore, one of your kids is the trustee, and if they have to go to nursing home, that money's protected from nursing home, from creditors, etc. And there's at least some kind of guaranteed money for the kids. specific bequests. What's a specific bequest? Well, some people want to leave a specific amount of money to, their church or a specific charity, Middlesex County Bar Foundation, whatever. So that has to be specifically in the will, and also a clause that says if the entity ceases to exist, who would get the money, so it doesn't end up in court. And someone says, "Why should I do that?" He goes, "Well, I left some money to, St. Thomas Aquinas High School. Can I guarantee that, 50 years from now, if I pass, they're still going to be in existence?" Some people will say, like, who would so the charity. Some people leave amounts of money to a grandkid to put away for a wedding, or something. There was a fellow years ago that was a member of the Monmouth Bar, and he put some money in his will so that once a year the people at the Bar Association would get a drink at one of their meetings. I thought that was funny. I wanted to put that in mind, but my wife vetoed that one. Some people want, sometimes the ladies will say, "I want my jewelry to go to this daughter or this granddaughter," because they know if their son is the executor, he's going to go to Cash for Gold and say, "What do you give me for this junk?" It could be a lot of it's, but it's the sentimental jewelry. Some clients think that their collectibles are worth something. Just like, we used to think, my son used to think Pokemon cards were going to be valuable someday. I used to think my baseball cards were going to be valuable someday, but they're not. I know people that bought Hummels thought they would be valuable someday. Well, they're only valuable to the person that sold it to someone. But again, if someone says that's what they want, hey, listen, we're a service provider. They can type it up and we'll put it in there. What they want as their specific bequest. And I've already mentioned what I consider to be the reverse specific bequest. I leave nothing to this person or that person. So now there's a question you want to ask people: are they married? And then I ask them, are they legally married? Some people are embarrassed to say they're not legally married. A lot of some of my Spanish clients, yes, I'm married. Are you legally married? Because if the word is spouse and they're not a spouse, you don't want anything subject to change. Some years ago, after we signed the documents, someone who I went to college with their daughter, I knew where the family lived. We signed the documents, and the fellow goes, "Does it matter that we're not legally married?" He goes, "Of course it matters. I mean, your daughter's 30 years old. What's the deal?" He goes, "Well, we got divorced 4 years ago, but then we never, after we saw the judge, we never went through and we never split up." He goes, "Yeah, but you're not legally married." Another fellow, after we sign it, he says, "Does it matter that's not my legal name?" I goes, "Yeah, of course." He goes, "What's your legal name?" He goes, "Elmer." I go, "Elmer?" He goes, "Yeah, but I don't like it. I remember a kid growing up, people made fun of me for Elmer Fudd. So, I've been known at work and, everywhere else as Joe." I go, "What does your driver's license say?" He goes, "Elmer." He goes, "Well, your name is Elmer. Your death certificate's going to say Elmer. Unless you go to a formal, we got, so, we got to, we put in the will to say, Elmer, last name, AKA, also known as, and it explained to him, AKA is not a dirty word. You see at the old post office when the people were wanted for murder, AKA a pretty boy Floyd. He goes, "No, it means also known as." That way, there's no dispute onto who's getting your stuff. If there's your questionnaire should ask a question dealing with who would be the trustee number one for money. They hold the money if both parents pass away. Some people are not married, divorce. We've done more and more estate planning for people that are separated because they realize, hey, if I pass away right now, everything goes to my spouse. My kids will get nothing, and right now, my cheating spouse is the least person on the planet I want to get my money. And also, we had to revoke old powers of attorney because they said, do you realize that 5 years ago you gave your soon-to-be ex-spouse the ability to get into all your accounts and change everything. Go into a bank, close the account out. So let's do a new one, and then notify the banks that the old power of attorney was revoked. Uh, Guardians, well, again, some people said I don't have anyone in the U.S. Does it have to be someone in the U.S.? No. I'd say if your family is all in India or the Philippines, that's your right. But if it's not a blood relative, I said, listen, do yourself a favor and ask the person first. And just don't throw their name into the will, hoping that you're going to live forever, because no one can be forced to be a trustee. No one can be forced to be the guardian. And in a probate matter, I was talking to a fellow that was named as the trustee in a trust for a disabled child. He goes, how much work is this? He goes, well, once a year you got to fill out a form. There's some money in the trust. It's not like you're a trustee where someone's going to be banging on the door, every day saying I need money for cigarettes. But planning, it's all about planning and explaining to people on doing things correctly. And it's ask the person in your interview form, is anyone receiving disability benefits, SSI, SDD? Is there any reason why they shouldn't be receiving money? Because what you realize is the parents that have children with special needs realize that you want to protect the kids and be able to have them not lose any governmental entitlements. But then you got the parents that their kid's a slacker, or they have an addiction problem, they're a gambler, and that if they got $100,000, they would blow it in a year. And so in that case, you can set up a spendthrift trust within the will to protect that person. You just got to pick, who's going to be willing to be a trustee for conceivably another 20, 30 years. But that way the money is protected from creditors, it's protected from taxes, it's protected from alimony, it's even protected from child support. We were involved in in litigation in Somerset County, and the lady had a spendthrift trust for her one son that was an alcoholic, and it gave the trustee the ability to spend money, so that way his apartment rent was paid, his car insurance was paid. They were able to buy ShopRite gift cards for him so he could buy food rather than giving him a Visa gift card where he could buy booze. Not that many of the ShopRites have liquor licenses. And the fellow's ex-wife filed a motion saying, Judge, I demand that in family court, I demand that you compel the trustee to pay overdue alimony and overdue child support. And the judge agree with me. The reason why we set this up is to protect those kind of assets and have some money there so that rent can be paid for when someone's 60 years old. Conceivably, rent could be paid when someone's 70 years old. So you never know. So before I go into the next topic of powers of attorney, I'm going to have John say a few things, but two things. Always do a self-proving will. Under the old, law, person signed and the two witnesses signed, and then one of the two witnesses had to go and sign paperwork in front of a notary, or go to the circuit's office, sign paperwork. Yes, I witnessed the will, and that was under the old way. So with the self-proving will, let's see, person signs, two witnesses sign, the attorney and notary signs, then we all sign again with self-proving will language, so that the family does not have to pay and locate the witnesses. Because I remember when my grandma passed, and one of the witnesses was not a self-proving will, and one of the witnesses goes, goes my dad, my fee's $500. My dad goes, we're not paying you $500. The lady goes, well, they get the other witness. And, well, she's dead. He goes, yeah, my fee's $500. Now, we could have said to the lady, hey, forget it. But then we had to file a complaint, order shall cost. The reason why I bring this up is I knew some offices that, even like 8 years ago, were intentionally doing non-self-proving wills so that the families would have to come to them, and they would try to, the attorneys was hoping to get the estate. And I remember saying to one of those attorneys, he goes, listen, you got to do the right thing all the time or not do it at all. I'd say that's like a doctor not doing the surgery the whole way through, hoping that the person could come back, and they could fix it, and then they'd have to, they could bill the insurance company a second time. So the will should have a clause, it should be self-proving and have a clause that says no bond required, because otherwise the family has to take out a bond. Okay. Now, John, you can hear me. What do you have? How do you do it better than Kenny Vercammen's office does it in Edison?